Good morning, all. This case management conference is in the matter of CFI 026-2024 before His Excellency Justice Robert French, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Al Obeidly and Al Zaroni, advocates and legal consultants. Lead counsel is Mr. Rafiq Pierre Mohedin. And the defendant is represented by ATB Legal Consultancy. Lead counsel is Ms. Asha Teresa Bajoy. Thank you, Your Honor.
Yeah, thank you, and thank you very much. I've seen the case management memorandum and your case management information sheet, and also the draft case management order. I gather from that the claimant doesn't propose to call any witnesses. That'll be a documentary case. Is that correct?
My Lord, I do understand, my Lord, that probably we might have to call a witness in view of, I understand your Lordship's observation in that order your Lordship made in the immediate judgment application, my Lord. Your Lordship had indicated the documentary evidence alone isn't sufficient. It doesn't seem adequate at the moment. We are proposing to call a witness. We are taking instructions on the moment. My Lord, if I may take for one moment, my Lord, just outside this, what your Lordship just asked. My Lord, in the case management information sheet, at point number 16 and 17 of my learned friend Mr. Bajoy's information sheet, may I refer your Lordship to point number 16 and 17, my Lord.
Just a minute. Yes, I see that, yes.
Yes, my Lord. Item 16 is, yes, a court-assisted mediation may assist the parties to resolve their dispute without the need for a trial and saving cost. And 17D, my Lord, D for Delhi, yes, only in the case of a court-assisted mediation. We had previously attempted an informal settlement process, but that hasn't been successful, my Lord. Therefore, I am acceding to the suggestion my learned friend is making in her information sheet for a court-assisted mediation because the nature of the claim, the quantum of the claim may not justify a full-blown trial given the costs are involved. My Lord, if your Lordship would give us an opportunity to see whether there could be a mediation between the parties to resolve the dispute, that might possibly dispense with the need for a trial. Should the matter go to trial, my Lord, of course, I have stated otherwise. I received the brief just yesterday, and I might, after taking with your Lordship's leave and after taking instructions, my Lord, I may propose to call one witness in this matter. The gentleman was involved in the correspondence, despite what is stated to the contrary in my information sheet.
All right, thank you. Yes, now, in terms of if you go to court-assisted mediation, it would seem preferable that happen immediately before any further costs are incurred in terms of document disclosure and so forth. Do you agree with that, Ms. Bajoy?
Yes, Your Honor. We are in agreement with the idea of having the court-annexed mediation proposed immediately after today's CMC hearing.
Yes. Could I ask the registry officer, Alia, how soon can a court-assisted mediation be organised, do you know?
Your Honor, the parties may email the mediation center. I can email the parties following the CMC today with the details of the mediation center, and they will be able to liaise with them directly.
So they go directly to the mediation center, is that right?
Very good, my Lord. We will do that. I will take the initiative and I will write to the mediation center, my Lord.
Well, I wonder if I should simply adjourn the CMC until you've and give you say 14 days to organise a court-assisted mediation, and we can bring it back on a date, but you don't have to proceed with it if the matter is resolved. I don't want to see anybody incur any additional costs in terms of particularly a document production process, although I suspect that down the track it might be sufficient for each party simply to produce the documents they're going to rely upon in the case, as distinct from a global process of production and objection and disclosure and all the rest of it, which often takes up a lot of time and expense.
As a matter of fact, my lord, there aren't very many documents in this matter, and the issue
I didn't think there were, actually. Yeah.
in fact, the issue has been narrowed down because the contract is admitted, the use of the test weights are admitted, the damage occurred in the course of the use is admitted. It comes down to two very narrow issues. Firstly, whether the weights were fit enough to be used. Secondly, whether it could be used. Was there a limitation that it should not be used offshore contractually? Effectively, it comes down to
I understand that. There was a request, I think, or an assertion that there was a need to see if there was any manual in relation to the operation of the test weights.
yes.
Has that been discussed between you?
Yeah, I think my learned friend has made a request in her information sheet. I was spoken to me instructing solicitors. I'd see whether there is any information manual. If there is, I will provide the same.
Yeah, obviously it could be relevant. So, well, I'll leave you to do that informally without any direction, if that suffices, Ms. Joy.
Yes, that's fine.
Yes, Your Honor, we haven't had a chance to discuss about this. However, yes, we would be able to do it informally after the hearing, today's hearing.
All right. Well, let me just have a look at dates. I want to have a date that you've got to get back by, unless the matter is settled. So we've got today's the 9th of September, or 10th of September, I'm sorry. So we go 10 and 14 is 24.
Also, Your Honor,
Yes.
sorry, if I may, please interfere. I was actually wondering if 14 days would be sufficient time for us to get the mediator.
Well, I'm just thinking that I'm thinking beyond 14 days. So I'm looking at maybe adjourning this to the 2nd of October.
Would 9th of October be convenient, my lord?
Would what?
9th of October.
9th of October probably would. Just a minute. Yes, I can do 9th of October.
And thank you, my lord.
So all I would order is that the CMC be adjourned to 9th of October, provided that the parties may apply to vacate that date if the matter is resolved.
Thank you, my lord. We are obliged.
Well, so the orders will be: 1, the parties are referred to the mediation centre. That's up to you, of course, to explore the possibility of a mediated settlement. 2, the CMC is adjourned to, now we'll make it the same time, which I think is 10 o'clock your time.
Yes.
Yes, Your Honor, that works for us. Thank you.
It'll be 2 p.m. for me, 10 o'clock UAE, yeah. And costs today reserved. Let's leave it at that, I think. Of course, I'll just say liberty to apply. And that is to apply to vacate, and that can be done on the papers just by correspondence, I would think. So we'll just vacate the date if it's all resolved. You may be coming back with, there might be consent orders if you do settle it, and that can be dealt with on the papers, I think, without the need for further premises. All right. Well, good luck to both of you.
Obliged, my lord.
Thank you very much. Oblige, Your Honor.
Thank you, Ali.